And hello once again. Welcome to the Employment Law Show. John Scholes, Lior Samfiru. You want to reach out, 1-855-821-5900, employmentlawyer.ca. We'll get to the pocketemploymentlawyer.ca website. I just threw it out there, but we're going to get to it because it's big and it's very important. Coming up on this show as well, we will get to what you should never do if you're an employer. On an earlier show, we covered what you should never do if you're an employee. We're going on the other side of the table now, so stick around for that. Lots of stuff to get through, some phone calls from our radio show. By the way, employmentlawyer.ca if you want to find a place to catch our radio show where we take the calls from. But that's all coming up in just a bit. We start with the week that was. Mon frere, how are you?
Well, I'm doing great,
Good.
Johnny, and it's great to be back here to talk about employment law and workplace rights. And you know, it's a privilege for me to be to do my job
With me.
Not that okay. Part of my job, not that. The rest of my job, when I actually get to talk to people and help them and solve their problems and hopefully make them feel better about their rights and their situation, that is a privilege. And I'm so happy to be back here to do just that. So we talk about your workplace rights, your job, what the law does to protect you and make sure that you have entitlements. So we do that on this show, but I do that much more in my office every day. So if you have questions about your specific situation, if you want to know if your employer is allowed to do something that they did, no worries, no hesitations, there's no bad questions. Call me, email me, we'll give you my contact information throughout the show. But on this one actually is interesting. I was taking the VIA train very recently, and someone stopped me there, had the question. I thought this would be a good situation for the week that was. And what she was telling me in that...
she recognized you?
She did recognize me.
Hollywood?
Celebrity.
Look out.
Thank you. She recognized me from the TV show. Said, well, I actually have a question. Do you mind if I bother you? Sure, no bother. So here's the situation. Her employer recently instituted a new policy that says that if you have to call in sick to work, then it's your job to find someone else to replace you. You have to make some calls to your colleagues, find someone, your job. Previous to that, the policy was, well, if you need to call in sick, call your boss, call management, and they'll take care of it. Right. So that was fine, except very recently what happened to her, she was sick. She started making some calls and looking for someone to replace her. Either she couldn't get a hold of people, or the people she got a hold of said, no, we're not available to cover for you. Mm-hmm. So what did she do? She called her boss and said, I tried, there's no one available, so I'm telling you I'm sick, I can't come in. Fine. She goes in the shift after that, a couple of days later, gets called into a meeting, we're letting you go, you didn't do what you were supposed to, you left us in a jam, you didn't show up to work, so we're letting you go for cause. So on the train, she's talking to me, she's asking me, is this legal? Could they have done that? Could they have let me go? So John, the answer is an absolute no. They could not have let her go. Why? Because she didn't do anything wrong. Now, what's the purpose of discipline? The purpose of discipline is to stop behavior that the company finds to be inappropriate or offensive. But what's the offensive behavior here? Being sick? Being sick is not a workplace offense. And she can't help what other people do. The fact that she tried to get a hold of people, she did what she was supposed to. The fact that they were not available is not her fault. So there's nothing that she actually did wrong here. So even though the company may be in a jam, it's part of running a business. You will have employees that are sometimes sick, that cannot make it to work. You can't punish them for that. Now, she did do what she was supposed to. They're allowed to have a policy saying you have to try to find someone. But if you can't find someone, that doesn't mean you get disciplined. You shouldn't be going to work when you're sick, for everyone's sake, yours and others. So if you're let go because you couldn't find someone, or even disciplined because you couldn't find someone to work to cover for you when you were sick, that is a wrongful dismissal. For this particular person, I assessed her as being owed close to a year's pay. She was there for 10 years. So John, I think it's an important thing for employers too to understand. It's okay to have a policy saying find someone. But understand that if the employee tries and cannot find someone to replace them, you cannot punish them in any way.
So the employer would just have to suck it up. There's nothing they can do about it.
It's the part of the cost of running a business. It's part of the process of running a business. You sometimes may have to be short-staffed or find someone yourself, or if you're the boss, work yourself. It's the way that it is, and you cannot punish someone if they're legitimately sick, if they legitimately cannot work. Ask for a doctor's note if you have a question or a doubt, but you cannot punish anyone in that situation.
Reaching out for you is simple, 1-855-821-5900, employmentlawyer.ca. As mentioned off the top, that is where you go to find a radio station where you can catch our show. Been doing that for about 8 years on radio. Ton of phone calls. First call for the day is right now.
I have been working for the same employer for the last 26 years without a contract. Recently, my employer has decided to pass the business on to his son. In the meantime, he has handed me a contract, which he is telling me I need to sign at this point because the pre-existing company name, which he now changed, is no longer in effect, and therefore I am not entitled to a severance. So I have already decided I'm not signing that contract, and in the meantime, they have started to make my life difficult, making my job difficult, excluding me from different things.
Do not sign.
Do not
Ever.
sign. So that's
That
a
would-
very smart person
Yep.
in that she knew better than to sign. So let's make it very clear, okay? If you're working, you have a job, and whatever the reason, maybe there's a new boss coming in, maybe there's a sale, maybe something else happens, and your boss all of a sudden says, we want you to sign a new agreement. No big deal, just sign it. Do not do so. Do not sign it. I can almost guarantee you that that agreement is going to contain terms, new terms that are unfavorable to you. For example, terms that limit your severance, terms that allow the company to change your job, to change your compensation. Don't sign it. The company can't make you, and you can't be penalized for refusing to sign. And can you imagine, John, signing an employment agreement like that and realizing a few months later, when maybe they let you go, that because you signed it, now you lost $100,000 in severance that you otherwise would have received? What a terrible situation. So for this person, they can't punish her for not signing. They can't fire her as a consequence of not signing in the sense that that's not cause. And if they are making her life miserable because she didn't sign, that could be a constructive dismissal. If she's being mistreated, harassed, bullied, what have you, she may be able to force the situation and leave with compensation. So the question then becomes, what would she be owed?
Right.
Whether they decide to just let her go, or maybe she forces a constructive dismissal. So let's plug her information into pocketemploymentlawyer.ca and let's see what she's owed. So we can see on the screen right now, she's let's say she's a supervisor, 26 years of service, we know that. She would be owed anywhere from 22 to 24 months pay. You can see that on the screen. It's as easy to do that as it is for me to read it. Pocketemploymentlawyer.ca, and depending on her compensation, we could probably imagine that's a six-figure amount that she's owed, 24 months pay. So that's what's at stake for her. And for you at home, if your employer asks you to sign a new employment agreement, don't do so. If you're not sure whether you should, if you're not sure what it says, what it means, call me. Let me take a look at it. I can review it and tell you exactly.
And if you give the okay after looking it over, do they not have to provide her with some sort of compensation for signing it?
Yeah, if you're going to sign a new employment agreement, for that agreement to actually be valid and enforceable, you have to get something in return for signing it. You can't just, your signature on a piece of paper doesn't make it legal. So a bonus, signing bonus, extra pay, extra vacation, something that you would not have otherwise received. So again, you're not sure what that means. You're not sure what you should get, whether you should sign. Does it affect you? Call me.
Again, help@employmentlawyer.ca is the email, but you just glanced over it. I want to get into it deeper. Pocketemploymentlawyer.ca.
So pocketemploymentlawyer.ca, we talked about it. It's a tool that I created to allow people to get an assessment of their legal rights when it comes to workplace law, workplace rights. So pocketemploymentlawyer.ca, once you go there, you're going to see some categories that it can help you with. It can determine the amount of severance that you're owed. Easiest place to go to if you lost your job, if you want to know how much you're owed. Even if you're just curious, you go to pocketemploymentlawyer.ca. But beyond that, if you want to know if you've been constructively dismissed, if you want to know if you're really an employee or an independent contractor. By the way, you're not an employee. You're not an independent contractor. You are an employee. If you want to know if you're a victim of harassment or of human rights violations, that and more, you can go to pocketemploymentlawyer.ca. It's free. It's anonymous. It's easy to use. It takes seconds. It's like having your mini Lior, God help you, in your pocket with you at all time. Pocketemploymentlawyer.ca.
Well, like we like to say, we'll take it out for a spin. I want to read this email, and you can use the Pocket Employment Lawyer in that regard. Karen writes in, says, I was recently terminated for cause after arriving late for work. In the 18 months I worked there, I was never late before and didn't have any issues on my record. Clean. My employer said that I am not entitled to any notice or severance pay or even EI. This is the boss saying this. Did he have a right to fire me?
Well, let's start with the idea that, yeah, if you're late, obviously you're doing something wrong. You have an obligation to come into work on time. But the fact that you were late, the fact that you did do something wrong, does not mean, not at all, you could just be fired. That certainly not be fired for cause, because the termination for cause is reserved for the worst offenders. Now, if you're always late and they've warned you and they've given you opportunity after opportunity and you still keep coming late, well, what more can they do? Okay, maybe then they can terminate your employment. But that is extreme. If she's late, she says, one time in 18 months, nonsense. Of course, they cannot legally let her go for cause. That's not cause, which means if they do let her go, they owe her severance, full severance, and it could be a few months' pay. But we've been talking about pocketemploymentlawyer.ca. So one of the ways she could have gone, or one of the places she could have gone to find out if there's actually cause, if being late is cause, is pocketemploymentlawyer.ca. So let's see how that looks on the screen right now. So she would have inputted the number of years, the type of misconduct that's alleged, and the fact that it hadn't happened before, that she wasn't disciplined before. And we can see the result at the bottom of the page. It says, since you have not been disciplined over the previous 2 years, and given that the allegations are not that serious, this is probably not a cause for termination, meaning severance may be owed.
Right.
So that's as simple as that. This pocketemploymentlawyer.ca just assessed her as not being terminated for cause, that she is owed compensation. That's how easy it is to use.
We'll take a short break. Coming up, what you should never do if you're an employer. Don't miss that. 1-855-821-5900 and employmentlawyer.ca. Lots more coming up in the Employment Law Show. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to the Employment Law Show. John Scholes, Lior Samfiru. Our topic for today, I know you want to get into this one. If you're an employer, you should never ... right?
So employers often give me a hard time, and they say, well, you're telling us about all these mistakes that we're making, and you're telling us about all these entitlements that employees have. Well, help us out. Help us avoid making these mistakes. So that's what we're going to do today. We're going to talk about a few mistakes that employers make that they should not make, because if they do, that's when they get in trouble. That's when they owe employees compensation. That's when they break the law. So this is important for employers, but employees as well. Because if you have an employer that's doing those things, you'll know now, wait a second, they're not allowed to do that, and here's what to do about it.
First one is a big one. It can cost you. That is, assume that there's only 1 or 2 weeks per year severance.
Probably the best place to start. And employers, just like employees do, assume, oh no, if I let someone go, I got to pay them a week's pay per year or 2 weeks pay per year. And they let them go and thinking that's all they owe. So here's your week's pay per year. And then they get a letter from someone like me saying, no, you actually owe them 18 months pay. Ouch, is right. Well, it's because they didn't get the right information. There is no such rule of a week per year or 2 weeks per year unless an employee signed an employment agreement that limited their entitlements, and many have not. So if you don't know what you owe the employee, if you assume it's a week per year, 2 weeks per year, or actually wrongfully dismissing the employee, you may have the best of intentions. You may want to be the best, most fair employers, but you could still be in breach of the law. You could still be wrongfully dismissing the employee, not knowing any better. So get advice. Call me. Go to pocketemploymentlawyer.ca. Speak to another lawyer. If you don't want to speak to me, that's fine. But it's not a week's pay per year of service if you want to do this right. If you don't want to be on the wrong end of a wrongful dismissal claim, ensure that you know your obligations, ensure that you provide the employee with what they're actually owed.
Talking about the things you should not do as an employer, number 2 is this: ignore allegations of bullying or workplace harassment. Really topical in the last couple of years.
It really is, and despite it being so topical, a lot of employers still don't know how to properly deal with workplace harassment or workplace bullying. So let's make sure that we understand. The first thing, what you don't do, and you just read that, is you don't ignore those allegations. If someone brings forward an allegation of workplace harassment, you have to take it seriously. You have to investigate. That may either mean you conduct the investigation, or better yet, bringing in an outside investigator to do the investigation to figure out what actually happened, to talk to the person that's complaining, talk to the other employees, get people's perspective, get as much information as possible. And if it's determined that there was harassment, you have to take measures to fix that problem. Maybe you have to discipline someone or provide additional training, have better policies, perhaps let someone go. But bottom line is you have to take these allegations seriously, investigate them. Don't allow your work environment to become poison. If you do that, you could be in breach of the Employment Standards Act, you can be in breach of the Occupational Health and Safety Act, of the Human Rights Code, you name it, and more. Bad idea to ignore these things. It's illegal, and if you're an employee and your employer is not properly dealing with workplace harassment, they're in breach of the law. You got to give me a call then.
The days of, boys will be boys in the room are gone, right?
It really is, and the type of behavior that may have been accepted 20, 30 years ago is no longer acceptable now. You have an obligation to ensure that employees are protected, that the work environment is healthy and supportive. It's an active obligation. An employer cannot ignore that.
Okay, employers don't do this either. Fire an employee while they're on either a medical leave or a paternal leave, right?
It's illegal. It's a violation of the Human Rights Code to let someone go because they're sick, certainly because they're pregnant or because they're a parent taking a parental leave. That is illegal. You cannot do that. Even if you think that they're not a good employee, unless you can show that this had nothing to do with the medical condition or it had nothing to do with the parental leave, that is a huge, huge problem. My best advice for employers, if you have an employee on a medical leave, let them stay on a leave. Assess your ability to take them back when that leave is over. Same thing with parental leave. Don't let them go. Don't be too proactive. Don't say, well, I know now that 6 months from now when you come back, I'm not going to have a job for you. Well, how would you know that? In 6 months, things may change. Don't be too proactive. Assess your ability to take them back then. Remember, there's a duty to accommodate. And if you do let someone go because you're on a leave, that is a human rights violation. It's certainly going to cost you.
This whole list is for employers. If you're an employer, these are the things you should not be doing. This one, we've done complete shows on that, is misclassified employees as independent contractors.
Let's face it, it's much easier for a company to have independent contractors. You don't have to remit taxes for them. You don't have to worry about silly things like minimum wage and employment standards and vacation and overtime. So yeah, let's just have them as an independent contractor. Well, not so fast. The law doesn't work that way. If someone is, in the eyes of the law, an employee, then they have to be treated like an employee. And people are misclassified. People believe that because they signed a contract that says, I'm an independent contractor, that makes them an independent contractor. And for the company, here's the problem. If you've misclassified the employee, well, you may then be liable for back wages, for overtime and vacation pay and overtime pay. That could be a huge liability. You may owe people severance you didn't anticipate. That could cripple a company. Yeah. So it's not a good idea to do that. Not to mention, by the way, we can get into trouble with CRA. So if someone's going to work for you regular hours, full-time, or even if it's part-time, but it's regular and it's consistent, they're probably an employee. They should be treated like an employee. And if you don't do that, there's going to be consequences. And for you out there, if you're working, but you're really on paper an independent contractor, remember, you may have rights. And that's especially important if you're let go, because then you should be getting your severance like an employee would. If that happens, you know what to do. You reach out to me.
If it was that simple, nobody would hire anybody. Nobody at your firm would be an employee.
Exactly. Why would anyone be, we have people working here in the studio. Why would they be hired as employees? They should all be independent contractors. It doesn't work that way. The law determines whether someone is an employee or an independent contractor. The individual doesn't decide that. The company doesn't decide that. A piece of paper doesn't decide that. The law looks at all factors to determine who really is an independent contractor.
Things not to do if you're an employee. Last one, we'll wrap it up for today, is this: terminate an employee for cause if you have not built up that case.
And we've touched on this earlier in the show about how difficult it is to terminate someone for cause. And employers often equate the idea of employee doing something wrong with a termination for cause. Right. The fact that an employee did something wrong is not enough. If you're an employer, the way you could potentially terminate someone for cause is building up a case, engaging in discipline, giving them warnings, giving them opportunity to improve, and documenting that. Once you've done that and the employee still is doing whatever it is that they're doing, maybe then you can contemplate a termination for cause. It's difficult to do, and it's not one of those things where you can just jump steps in the queue. build up your case, and then maybe you can terminate for cause. Otherwise, even if the employee did something wrong, you may owe them significant compensation. And of course, for employees, remember, if you have been let go supposedly for cause, I've been doing this for a very long time, and in my experience, in most of those cases, when you are let go for cause, really in the eyes of the law, it's not cause. It's still a without cause termination, and severance has to be paid.
We keep telling you to reach out. It's simple, 1-855-821-5900, help@employmentlawyer.ca, and employmentlawyer.ca, the website to find the radio shows you can listen to, past shows as well. You can download them. We'll get to phone call number 2 from the radio next.
My wife has worked for a large retailer for 4 years, full-time. They closed the location. They're going to reopen it again at a different location in a year. They all got permanent layoffs. They were forced to sign a letter that night when they were told, basically saying they will be getting no severance at all. So it'll just be her final pay and then vacation pay.
Permanent layoff.
Well, that's a termination. You know, you can call permanent. I mean, I don't know how could it be more of a termination than that. You're permanently not working for us anymore, right? That's a termination.
No, it's a layoff.
And you know, I take a step back here. I've often heard from people that say, well, I had no choice but to sign. What does that mean, you have no choice but to sign? Well, was someone threatening you with a baseball bat?
Right.
Were they threatening to harm you or your family? You always have a choice to enforce and at least inform yourself about your legal rights. But that aside, okay, if you've been permanently laid off as this person, of course you're owed compensation, you're owed severance. It doesn't matter what the company believes. It doesn't matter, frankly, what you believe. The law makes that determination. So we know this person has been let go. We know they're owed severance. Question is, how much severance? I can tell you easily, but let's go back to our friend, the pocketemploymentlawyer.ca website. Let's plug this person's information in and see how much she'd actually be owed. So let's say she's in a customer service role. We can see that on the screen. We know she's there for 4 years of service. She hasn't been paid anything because her employer says, we're not paying you. I can't imagine why. Right. Well, the pocketemploymentlawyer.ca website correctly assesses her as being owed about 6 months' pay. Depending on what she earns, that could easily be tens of thousands of dollars. 6 months' pay, that's how easy it is to go to pocketemploymentlawyer.ca, whether you've been laid off, terminated, restructured, discontinued, whatever the term is. If you lost your job, pocketemploymentlawyer.ca.
We'll take a short break. If you've been bullied at work and ignored by HR, we will tackle that after we come back. 1-855-821-5900 and employmentlawyer.ca. It's Employment Law Show. Stick around. We'll come right back.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. Thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Employment Law Show. You want to go to employmentlawyer.ca to find a radio station where you can listen to the show, past shows as well. And currently, we'd love to have you tune in and make some phone calls as well, ask some questions. We play those calls back on here. And phone call number, 3 for today is right now.
I've been working in a workplace, and I've been bullied for about 4 years now. This employee is a long-term employee. He's been there for about 25 years. He has a long history of bullying. HR has a huge file on him, but they won't do nothing about it.
File's no good if it doesn't become active.
Well, you know, what did I just talk about in terms of things that employers should not do? And I said you should not ignore workplace harassment, workplace bullying. And it seems like that's what the company is doing here. There's harassment allegations being brought forward, and the company's not properly dealing with that. Well, that's a huge problem. It's a huge problem because it creates a poison work environment. It makes it difficult for the person to continue working. I've seen many situations where, as a result, the person ends up going on a medical leave, you know, depression, anxiety, whatever it is, and that's not good for the person. It's not good for the workplace. all the company has to do is take it seriously, investigate, and take measures to deal with it. So you know better now. If that happens to you, if your employer won't deal with the workplace harassment issue, come see me. By the way, you can also go to pocketemploymentlawyer.ca if you're not sure whether your matter qualifies as workplace harassment. If it rises to the level of workplace harassment, pocketemploymentlawyer.ca can assess that as well. But workplace harassment, not acceptable. Deal with it, employers. You have to. The law makes it very clear.
And this person's got a history of it, she said. Like, it's not the first time they've done this, right? Like, get on it, right?
One of the things she may be able to do, if her employer is not going to deal with it, to say, well, enough is enough. Now I'm going to treat this as a constructive dismissal. Now I'm going to leave and require the company to pay me severance because they're making it difficult for me to continue working. So that's an option that's available to employees that are being mistreated, where the company is not fixing the problems, they're ignoring them, they're not doing enough. You may be able to leave your employer, but still require them to pay you your full compensation. That said, I don't want anyone quitting me without speaking to me first, but that's definitely an option.
Another option for you to reach out is terminationquestions.com. It's simply you go there, you can ask your questions. They will be answered by either Lior or a member of his team. There's a drop-down menu to search past questions as well. Pretty robust, so you want to get in there and ask your questions. They will be maybe brought on this show and we'll talk about it like Cal. Cal says, again, through terminationquestions.com, says, can I ask my employer for time off work to observe religious holidays?
Yeah, and that's a common question that I get. And different people have different religious beliefs, follow different religious traditions. And if it's a legitimate religious belief and a religious requirement, then yes, you are able to ask your employer for accommodation. The Human Rights Code requires the company to accommodate for religious reasons. So maybe you observe the Sabbath, or maybe there's a holiday that requires you to leave early because you're fasting, or what have you. That's okay. The company has to provide accommodation. Now, employers often say, well, how do we know if it's legitimate?
Right.
How do we know if they're really following it? Or maybe it's just, well, we want to go home early to watch the football game, but we're not following the religion. Well, if there's questions about that, and I wouldn't utilize this too much, but if there's legitimate questions, you can ask the person to bring something from the religious person that they follow, a minister, a rabbi, and confirm that they're in fact part of that belief and that there's a requirement to do these things. That's especially true if you're dealing with maybe a religion you're not as familiar with and you're not sure, is there really a requirement that they leave early on Friday, for example? You can ask for a rabbi, a minister, whoever the right person is, for their confirmation of that. I wouldn't do that for everything. If you know you have a Jewish employee and they want to observe the Sabbath, it would probably be overkill to say, well, I want something from a rabbi. But in some situations, it is okay to ask for corroboration, but ultimately, an employer does have to accommodate their employees' religious beliefs, even if it's not the easiest thing to do.
Is there a limitation to it, or just at will, as much as they need?
There really isn't any limitation. Now, there's a line that an employer does not have to cross if it becomes too difficult. If it's going to be so disruptive and so costly to the workplace, an employer may not have to go that far. But the fact that it is difficult and there is some disruption, that's not enough for the company to say, no, we don't want to do that. We call this accommodation to the point of undue hardship. So even if it is hard, the company still has to do it. And by the way, that doesn't just apply to religious accommodation. Oftentimes we see that in the context of the disability. Yep. Maybe someone has a medical condition that requires modified duties or modified hours. The company has to provide that accommodation. If the company says no to that, that could be a human rights violation. So if that happens, you know what to do. You can, by the way, also go to pocketemploymentlawyer.ca to find out more about that, or just give me a call.
Lots of good stuff there. Thanks, Cal. Once again, terminationquestions.com is where Cal went. You can use that as well, or email help@employmentlawyer.ca, or simply employmentlawyer.ca is the website to catch a radio show and listen back to old shows. And we've talked about it several times. We've used it 3 or 4 times. Pocketemploymentlawyer.ca is also a fantastic resource, completely anonymous, and there's a contact button, at the top right on that side whenever you use it. 1-855-821-5900 to reach out as well. We will catch you next time on the Employment Law Show. Thank you.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.
Thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.